Serious Injury Lawyer. Thanks all for coming across. Fantastic attendance. Brilliant. My name's Alex Aldridge. I'm the publisher of Legal Cheek, and with me are a panel of top serious injury lawyers. Let me introduce the panel and we'll get straight into the questions. So, next to me is Mark Tempest, who is head of the Serious Injuries Unit of Fletcher's Medical Negligence Practice. Next to him is Ed Fletcher, Chief Executive of Fletcher's. Next to Ed is Amanda Yip QC, who's a specialist serious injuries silk at Exchange Chambers and a Deputy High Court Judge. And on the end is Adrian Denson, Head of Fletcher's Serious Injury Practice. So the purpose of this event is to look beyond corporate law. So university law faculties tend to bombard the students with information about careers in the city, and there's a really disproportionate amount of information that goes into explaining those jobs at either City of London firms or big corporate firms. But actually we find at Legal Cheek among our readers is there's a huge interest in other areas of law, and this area of law, sort of high-end medical negligence, serious injury, it gets, a lot of students really want to work in it. And I mean, it's a testament to the fact that, you've all come tonight to listen to all these lawyers in this area speak. Some of the things that are going on in this sector are amazing. I mean, Fletcher's itself is a great example of that. It has gone from being a high street firm to being the biggest medical negligence law firm in the UK. It sponsors Judge Rinder, the TV show, which I'm sure you're all great fans of, as student daytime TV watchers. And only this week Fletcher's was named in the Sunday Times top 100 companies to work for, alongside a host of kind of top City of London law firms, knocking Baker and McKenzie out of the list on the way. At the same time, this is a segment of the market which is in a state of flux, and there are a lot of changes happening, and the government are heavily involved in currently encouraging this push away from low-value work to high-end work as they discourage smaller claims. So anyone who's read Adrian's articles, Adrian Denson wrote an article for us on Legal Cheek a couple of weeks ago talking about his journey into the sector and how he'd seen all these changes and how it's very different for students coming in now, often in quite a good way. We'll have a little bit of a sense of that. So let's just open this to the panel, and let's start with Adrian. So, I mean, what do you advise these guys who are looking at this practice area and they're coming in? I mean, what about pursuing a career in this area?
First of all, what I would suggest is that getting into personal injury law, if you want to become a great litigator, somebody who can manage a large caseload, you can develop your client care skills, you can deal with all sorts of different types of liability scenarios in personal injury work, you want to deal with all sorts of different procedural matters in respect of every different aspect of the CPR, all the way through to appeals potentially. And I did have an appeal on a fast track case when I'd only been practicing for a couple of years that I saw through and was successful on. So that sort of thing is possible. I do think that young lawyers coming into our industry can be, because you're sort of told this from various people, can be maybe a bit reticent to consider getting into personal injury work unless you can get into high-end stuff. If you can get into high-end serious injury work, that's what I do. I will always say that that's the gold standard of personal injury work. But absolutely, to get a great grounding as a litigator and as a personal injury lawyer, if you can get into a good firm doing fast-track work, then absolutely do it. There is no shame whatsoever, because I think sometimes it almost comes across as people think, it's a bit, I don't really want to become a general fast-track PI lawyer, it's a bit embarrassing almost. Do you want to admit to doing that? Absolutely not. That's the way I did it. I loved it. It turned me into a great litigator. I think it's such a fantastic grounding. If you can get into doing PI work that way, the most important thing is getting into the right firm, not necessarily getting into PI at what you might consider to be the right level. So that's what I'll say about that.
with the changes, the government changes, I mean, at the moment they're looking at whiplash claims not really being viable for lawyers anymore. Is there still enough work around at the junior level for these guys to cut their teeth on?
For me, Alex, yeah, I'd say absolutely there is. And just to echo Aidan's point, which is a really good one, is that I think it's the firm that you pick first and foremost, and then it's building your career within that organisation, as opposed to the type of work that you start with. Now, we've had a number of trainees who have lived only in the rarefied world of serious injury work, working with AD, just doing tetraplegic, paraplegic and head injury cases. Now, I always feel they miss part of their education as a litigator in just doing that type of work, because the cut and thrust of the lower level cases, getting used to court procedure, getting used to making applications, meeting deadlines, is all part and parcel of the job. So that's what I say about that. And absolutely, it's there is a thrust towards making sure that the smaller value whiplash cases are commoditised as much as possible. So it's quite button pressy, but Fletcher's actually, because we do bite work and serious injury work, in particular on with medical negligence, that isn't such of an issue for us.
Mark, your journey into the profession, was it a similar one to Adrian, starting at the bottom, working with
Absolutely. And I think I would kind of say that it's really important to be a rounded individual, have experience as a person, because you're dealing with people in crisis. So you've got to have experience, and your career is a long career. So if you go into serious injury really early on, and that's all you do for the rest of your career, that's quite a long time. I think it's quite a good idea to think about your career in the law. And if you're interested in litigation and if you're interested in serious injury, it's really good to have experience as a litigator in all fields. So, my background is, I started my training in a small high street practice, did crime, family, all of those types of work. I did a stint in the West End practice doing media law, but a lot of that was civil litigation. And then I came back to a more kind of provincial high street practice where I slowly grew into personal injury work and eventually clinical negligence and with that serious injury. So I would think about your journey in your career in law as a lifetime journey. You're forever learning. And we've been in, as you've alluded to, in an environment that's been forever changing as well, and sometimes in very, very challenging ways for us. But as law firms, and as lawyers, we've had to adapt. And Fletcher's in particular is really at the forefront of adapting to what's happening now. So I would counsel, don't be in too much of a hurry to get where you think you should be, because it's a good life in the law if you can make that journey.
Amanda, let's get the barrister's perspective of this practice area.
Well, I had a very broad practice to start off with. So I've been at my Chambers Exchange Chambers right from when I started as a pupil. I started initially doing basically a broad common law practice. So I was doing criminal law, family law, personal injury, and I did do little bits of commercial law as well. In fact, when I started, I was being encouraged to go down that route. But I think everything else was interesting. You could be representing someone who was facing a custodial sentence. That was obviously a lot of responsibility and important. Representing someone who'd been injured and trying to help them to get compensation for loss of earnings, even a relatively modest claim, is important to the individual. Or dealing with divorce and where children were going to live. Or my experience of commercial law was sort of arguing about a photocopier, and I'm afraid I just didn't find that as exciting. So I knew I wanted to do something that involved that human element. And for me, personal injury offered the opportunity to do something that was intellectually stimulating. I think particularly the clinical negligence work where you're conferring with doctors and talking at a high level about medical issues, I find that challenging and stimulating. And at the same time, you're doing something that really matters to people. So that's how I ended up where I am.
Okay, well, let's open this up quite early because you've all submitted some great questions, and it's the whole theme of this is an interactive question time event. You've got these top lawyers to, before you to ask whatever questions you like. Let's take a question. Come on, be brave, be brave. Who's going to? Yes, thank you.
Adrian, what's the most fascinating case that you've ever worked on, if there is one?
Crikey. That is a great question. Can you think of any?
I can think of one for me personally. I can't think of yours.
It's
Do you want me to
fantastic.
answer?
No, it's a great question. A good example is a case which, because a lot of you are relatively local northwest, aren't you? You might have seen the Crane case. I can give you his name because he was never off TV. Really, throughout the course of the case, Ian Gillam, and he was a chap who was on a crane, a high tower crane in a wharf in the Liverpool docks, and he was riding the cab at the top, and the pylons that connected the crane to the base of it failed, and it collapsed, and he came out of the cab and he was thrown onto the roof of one of the tower blocks nearby, and then the counterweight of the crane came over, and just when he's landed on the top, that was bad enough. The counterweight of the crane comes down and hits the top of the building that he's on, and he fell several hundred feet through the floor, and it took several hours for them to bring him out. He was spinal cord injury, complete paraplegic, with all sorts of other complications, and he also suffered a serious brain injury. And it was a really interesting case, and we had 4 different defendants. We had the company that was in charge of the site at the time, his employers, who was a different company, people who built the base, the people who designed the base. 4 different defendants. In fact, I remember we took the decision to bring the 4th defendant into the case on the last day of limitation. A lot of you will know how important limitation is to solicitors, and it's possibly the number one thing that might keep us all awake at night, the prospect of missing limitation, and a professional negligence claim might follow. And I remember the 4th defendant was in liquidation, so I had to go to Manchester and serve the liquidators with the proceedings on the very last day before I was out of time on limitation. And nobody would come down to accept the papers. So I said to the receptionist, I can't go anywhere, you're going to have to send somebody down, it needs to be a senior person. The receptionist said, well, I'll take them off you if you like. So I'm sure you're very important here, but you're not quite qualifying for the type of person who needs to be served with these documents. So we served the 4th defendant, and eventually we were successful, and it was a multi-million-pound case, and it was a high-profile case because it was in the news a lot. Ian liked to talk, particularly as a result of his head injury. So he never turned down an interview with ITV or BBC. So a lot of you will have seen him, whether you can sort of recall the case or not. I guarantee that most of you probably will have seen him on the telly. And it was a great case because it had a little bit of everything, but like all serious injury cases, what's at the centre of it is an individual, it's a person. That's the great thing about what we do. Going back to Mandy's point about commercial law and photocopiers or disputes between 2 faceless corporate entities, it's not quite got a catastrophically injured person at the centre of it who, through no fault of their own, has had their life changed and needs so many different things for the future. And that's what we're there to provide and help with. So we've got some great stories. Ian Gillam was one, but we've got so many others. Some terribly tragic, some interesting, all sorts of different stories, but really what's at the centre of all of them is an individual. And if any of you read the article that I wrote for Legal Cheek and for Alex, one of the things that I put in there is that I'm yet to speak to any lawyer in any other walk of legal life who can tell me that they have that same level of personal contact, of job satisfaction, because you're dealing with individuals who usually, through absolutely no fault of their own, are injured, and they really need your help. And a great privilege, again, one of the things I put in that article, sorry to go on, but it's a massive privilege. This sounds really corny, and I always say this. I'm never in the pub and somebody says, what do you love about your job? I'll say, It's that privilege that somebody at their lowest ebb, when they're utterly vulnerable and when they push everybody else away, they pull the shutters down, they don't speak to friends, they don't answer the phone anymore, but they let you into their lives at that point and they trust you. And it's a massive, massive privilege, and I cannot sell serious injury work enough to any of you. However you get into it, it's fabulous, it really is. It's a privilege.
Just got a question about what a trainee would be doing on a big case like that.
Some of my trainees are here at the back, and they should probably tell you
All the work.
All the work.
That is the answer.
Do they get to me climbing? What? I'm just curious.
Yeah,
If,
they absolutely do.
yeah.
And what they will do is, again, we'll always say this to all the trainees that come into the team. You will, in any given day, you will speak to QCs. You'll speak to senior managers within the firm. You'll speak to clients. You'll speak to medical experts. You'll speak to accident reconstruction experts. You'll speak to clients' families. You'll be counselling distraught family members, and then half an hour later, you'll be speaking to a medical expert on a case. You'll be there in conference with counsel and medical experts, and very often you might be taking a note, and you might not necessarily be offering all of the answers or all of the solutions in that conference, but you're there, you're part of it, and you're massively, massively important. Amy's at the back, my assistant, without whom I wouldn't be here.
I've just had a conference this afternoon actually at Fletcher's with an assistant solicitor because the solicitor who's dealing with it wasn't available today. So I've been saying to him, well, what do you think? And he's gone from having started out and just coming along and very much an observer to now I value his opinion. And pretty quickly, really.
So I think we'll come back to the theme of most memorable cases because we've probably got some great war stories here. But let's take another question.
I'm going to essentially put across an opinion. Feel free to destroy it. I think you mentioned faceless corporate entities, and you've mentioned that many students tend to look away from commercial, are interested in other areas. And I think one of the issues in regard to all this and a career in the law itself is you spend, 70,000, 80,000 on a law degree, you're paying for your exams at the end of your career itself, and you need to ensure there's some level of not value for money almost, but knowing that there's some level of progression as well in the firm itself. How would you describe progression from Fletcher's, as opposed to, obviously it's growing massively, where can you go as a trainee, and can you ensure that there is that level of value for money you're paying so much for a degree in the first place?
That's for me then. Right. What I would say is, it's not up to a company to give guarantees of value for money for somebody who's gone down the legal education pathway. I'd say the onus is very much on that individual to make themselves indispensable to the organisation. Now, actually, great example, get prepared to blush, Amy, but I should imagine if Amy was, for whatever reason, taken away tomorrow from you, you'd find things very, very difficult to move on, even though we've got a team of people that work with Amy. Amy's been able to do that. And what I'd say is that obviously puts you in a great position to grow a fantastic career within that organisation. And certainly at Fletcher's, working with Sarah Duxbury, I have people that a lot of you know and get to know. We've got a spotlight programme that anybody who illustrates the values of being a Fletcher's person and understands the culture and really throws themselves into the Fletcher's experience will be given every opportunity to develop themselves personally and within the organisation, and we'll provide that person with a career pathway. So it's the question about, I personally feel this is an independent conversation which we now have out of after this, but I think legal education has been treated like an industry, and I think people have been sold false dreams, to be absolutely blunt, and I think it's only the creme de la creme of you guys and people coming through who are really going to make a huge splash in the law, but the opportunity is still there, and for my money it's still the best profession in the country if you look at other industries, And, you know, just touching a little bit on what Adi and Mandy said, it's dead hard for us not to speak passionately because we've been dealing with incredibly badly injured people for so long now. But, you know, I can't think of another profession that stimulates here and here quite so much. And if you're the type of person who likes stimulation of both, this, for my money, is still, you get bang for your buck.
I think I'll just add to that. I mean, I'm reasonably new to Fletcher's, and I've worked in other law firms as well. Wherever I've been, you've got young, bright people who come in. They very quickly make themselves indispensable, actually. You know, you're ready to go. So you come in, and we have a need. You come in and work for us, and we can use that, and it helps to grow the firms. And that's exactly what's happening at Fletcher's at the moment. I've got a great need for people coming through. So, just encourage you really that it's still out there to be done. I'm not saying it's easy, but it's still there to be done.
Here's a question though. What if you're a real hot shot, right? One of these guys, real hot shot, and you want to do a career in this area? Do you go to a law firm like Fletcher's and get through it, or do you go to the bar?
That's a great and controversial question. Right, I'm not going first on that one.
Take that.
I think there's an element where quite a lot of people are going down the paralegal route anyway, and because it is very difficult to get either a training contract or a pupillage straight away. So we certainly are taking quite a few people who have become paralegals and they have networked a bit and grown their experience as a lawyer before embarking on pupillage, and I think that is becoming more common and also is a good route. Speaking to people over the last year or so, we have been actively encouraging that. And that gives you an opportunity then, I think, to explore both sides of the profession, because you will be working with solicitors but also being exposed to barristers going to court and that sort of thing.
What we're hearing quite a lot of the moment with all the difficulties of getting a pupillage is actually if you really, these days you should be getting into a firm and you should be looking to progress as a solicitor advocate. Do you think that's fair?
I don't know, you've got to do something to stand out. But I mean, I still believe passionately that the independent bar has a future, and that people going into pupillage and taking the sort of route that I did, there will still be an opening for that. But no one can expect to walk into that, however bright you are, whatever your academic qualifications are, because every year we see CVs full of A stars and all sorts of extracurricular activities, and in itself that isn't enough. Now actually tomorrow I'm doing a mock interview for somebody who their academic achievements are abysmal, but they've got something about them that I really think that they could succeed at the bar. So sometimes there's an element of just getting out into the real world, so that you can demonstrate real life skills as opposed to just grades on a piece of paper.
Let's take another question.
I worked, just a bit background, I worked for about 11 years in PI litigation on the opposite side for an insurer. You might remember, Eagle Star in Manchester.
Yeah.
So I had some of your letters coming my way. So by a circuitous route, I then come back to law, doing the GDL and the LPC. But my question is to the panel, prior to the Lord Wolf's report and the Jackson report, how would you say life was before and life is now after in terms of costs, computerisation? How is it easier now? Is it better now, or is it worse?
Do you want to answer this one?
I think elements of, well, it's just different. I mean, obviously there was a time when there wasn't computers on desks, so that was very different, and these people probably can't imagine that. I think it's easier in some ways, and we're much more specialised now. I mean, as I described earlier, I started as a general litigator. We're much more specialised. I think it took me 5 years before I saw the same situation again as a qualified solicitor. You know, if you're doing nothing but serious injury, you start to understand the differences between spinal cord injury, different types of spinal cord injury, or different types of brain injury. We're much more specialised, and then as a degree of standardisation that comes with that, you understand this, you've seen it before. So I think that's one of the big things that's happened with the law. So you're looking at Fletcher's, which is essentially a personal injury law firm, which is it's not uncommon now, but it was back then. So people are more generalised. So that's probably one thing I would do with one.
I actually think that because of commoditisation and more things being process driven, it's enabled us as lawyers to spend more time being lawyers and do the stuff that we're excited and passionate about, which is doing the really exciting stuff for clients. So we don't have to do a lot of the boring menial stuff we did have to do 10 years ago, pre-Jackson, pre-Wolf. And that's the way I look at it, certainly.
I think there's more pressure on you guys then. I think, in the old days, if you were late on filing witness statement, you'd just go to court and you would just get an extension. But I think there is probably more pressure, but you know the expectations, so you've got to live with that.
The other thing is you don't go to court as often, which I think is a great change. You don't get to hone your skills of advocacy and marshalling evidence and so on. So I think that's a great change. It's something that I try and address with my staff in the way that I coach them along. Really, I put them to the test when they present a case to me, in order to get them to advocate and think about what's the evidence supporting what I'm saying.
I came into the law at the time of the Wolf reforms. So, you hear all the stories about what happened before, particularly quite the opposite of the cards on the table approach. You hear all these great stories from much older lawyers like Mark, obviously. People would turn up at trials and serve things at the last moment, and you remember all this sort of thing. Things are a lot better now. We seem to focus a lot on the restrictions placed upon us by, fixed costs at that lower end. I don't work at that end now, but I do know that you still need great lawyers at that end. You still have the opportunity to thrive as a lawyer, to practice the law, to see the CPR in all of its glory, to be dealing with applications and trials. I know we don't get to court, Mark's right. We don't, even at any end of the personal injury spectrum, you don't get to court as much as you might like because we're lawyers. Often we say the only people who enjoy going to court are the lawyers, because certainly our clients don't want to go there most of the time.
But we do a lot of what we call joint settlement meetings, which can be day long and longer than that sometimes. Negotiations where we're there as a team of lawyers, and we'll be there with somebody like Mandy, and the client will be there, and there'll be probably 3 or 4 rooms in use, shuttling to and fro, and maybe a mediator involved, and those are very exciting events and also very satisfying, because you might have spent 3, sometimes 5 years working on this case with this family, with this situation, and that's when you bring it to conclusion, and that's such a massive event for us as well, actually, but for the individual and the family. So we don't go to court, but we never used to do that before. There wasn't settlements in that way before. It came as a result of the
It's become the norm now, the cases are settled that way. But just in terms of how things change, I do think there's a doom and gloom aspect to this, and we're thinking, things are changing, usually for the worse, it's only going to get worse, it's only going to get worse. The big change that I've seen in dealing with serious injury cases since I started doing them over the course of the last 10 years. 10 years ago, it was all about the end game. It was all about compensation. It was all about getting the right money for your client, whether that's £100,000 or £1 million or whatever it might be. And there was very little focus back then on rehabilitation, during the course of the case, you as the lawyer coordinating your client's pathway to getting better, bringing in case managers, bringing in therapists, sorting out their accommodation issues, making sure they've got the right vehicle, making sure that they've got all of the right aids and equipment, the right wheelchairs. What the focus wasn't on that as lawyers, certainly the way that I was trained at my previous firm. I don't know whether it's representative across the board here, but the focus was so much on making sure that we just got all the evidence in place so that we could get the right amount of money for our client, that really our client, in terms of their rehabilitation, they were almost left to it because we were focused on that end game. And now the biggest and most important change I've found in the time that I've been dealing with these cases is the focus. There's at least equal weight now placed on us getting the rehabilitation right, getting interim payments where we get the defendants to pay chunks of the money as we go along before you get to the point where the case is ready for final settlement. And with those chunks of money, those interim payments, putting in place all of those things that they need to help them rehabilitate as far as they are able to do so. Very often our clients will never be what they were before the accident, but by focusing on rehabilitation, we can get them as far as they're able to do so, given whatever their injuries may be. And so
all
now,
those points are professionally rewarding, aren't they?
they're massively rewarding. It's the best bit of the job for me, almost. Yeah. JSM's, joint settlement meetings that Mark's talking about, they're fantastic. We had one this week, it's a multi-million-pound settlement, settled the case, great, what a massive buzz. But really, on the day-to-day level, helping our clients rehabilitate is the biggest change that's happened since I've been doing this work, and it's the best change. So, you know, there is a focus on, oh, everything's always doom and gloom, change for the worse, wolf reforms, fixed costs, oh God, isn't it all bloody awful? But actually, you know, there are some great developments in this area of law, and we're part of that as well, and that's a great feeling to have, I think.
Let's take another question.
Hi, I just wanted to ask, as you brought up the mention of the fixed fees for clinical negligence in particular, I know that there's some opinions saying that this might cause the NHS litigation authority to drag out proceedings, but also, you know, it could be a way of sort of helping, you know, things speed up if there's financial incentives, things like that. So I just wondered, with Fletcher's, specifically with your relationship with health professionals, is there a sort of ability in the future, are you looking into working with them to help speed this up for the benefit of the customer? Just because personally I'm a physiotherapist, so from the health professional side, I think.
Well, that's a brilliant question, and obviously I'm personally spending a lot of time looking into that now, working with you know, the various agencies on a solution, and certainly, you know, my mantra is fast, fair settlements, because Hayley alluded to it earlier, and I'm sure Mandy, with everyone that she's represented, can bear this out. I've never revisited a client a year, 2 years, 10 years after settlement, and they said, you know what, Ed, I had a really great time going through the litigation process. It made me really relaxed, really chilled out. They've always said, even the guys who were dead relaxed throughout the process, say, you know what, all the way along, it was as if I was holding this great big boulder above my shoulders, and it just, it disappeared once it was all over. So aiming for fast, fair settlement suits the injured person, it suits the NHS, and actually, if we're looking at it pragmatically, it suits us as lawyers, and that should be the aim, and we should be looking to work far more collaboratively, trying to get rid of the adversarial nature wherever we can, and actually have that as a focus for how we move forward. And hopefully we'll see a system at the end of the consultation process that's going on at the moment that actually promotes that. Hopefully.
This is a long-winded question, for anyone, everyone. Did you ever have a career-defining moment, either an epiphany or breakdown, meltdown, because of the cases of people that you're working with? And how did you, obviously they're very difficult, sad cases, how did you kind of get over that? Or did you?
All the time. I mean, my most recent thing, I've been dealing with a client who is a very intelligent man, was a happy family man, but as a result of a brain injury, he has no insight into his behaviour, he has become very rigid in his thinking, and he's really difficult to deal with. And when I first met him, I thought, well, it's okay, it's just a matter of time, because I've done so many of these cases, and you often see at the beginning a real resistance to support. But as you move through the case, they come to terms with it. but this man hasn't at all. And I think it has been a real challenge because we haven't achieved as much as we would have liked to. But actually we've got to the end point of the case, we've had a settlement meeting, we've got a very good settlement for him, a very good settlement, although he can't quite see that because he thinks that he's got a better way of calculating damages than the lawyers have. But I think the challenge there, and I know my solicitor found it very challenging, was to realise that actually sometimes you can't achieve as much as you want to. And Adrian talking about the rehabilitation, that for me is key as well. Our roles as lawyers, I think, are very different from what people conventionally think of as lawyers. And for me as an advocate, the advocacy is perhaps more subtle than a lot of people think of as traditional advocacy. But you want to achieve something at the end. And sometimes it isn't quite possible. But then for that story, I would have at least 20 stories where we've had the same challenges and we have got to where we want to.
Just dealing with that emotional side, because that was one of the questions that came through that you'd submitted through the booking system was, how do you do it? These harrowing cases, day in, day out. Adrian, you talked about that a bit in your article and how you were an emotional person and then just kind of managed to get through it. I would find that hard. How do you deal with it?
I don't think it's actually easy. I think it does have a cost actually over time. Yeah. So I certainly thought it didn't. I thought you keep a good professional distance. It's actually really important to be so many things. I think to a serious injury client, you need to be objective enough. Even the client has to be absolute centre of everything. And bear in mind, the family's very involved and often has conflicting interests. So you've got to work all of that out. So you kind of got to have your mind on so many things really, but you also have to be close enough to get that trust that Ada was talking about. But without you can't become attached, you can't become influenced. But I think over time, yes, it does. I think that you can't detach yourself. But in the situation you've got to. So you've got to find your own way of coping with it. And I think for some people that is too difficult, and it wouldn't be the sort of thing that you would go into. I think you've got to either have or acquire the emotional intelligence to cope with that. And I think a lot of technical lawyers that will be doing commercial work, and I've come across a lot of people doing private client work as well, who work with the public, but they're not working with the public. Might be making a will for somebody, but they're not so intimately involved in their lives the way that we are. So I actually think, and again, I totally agree with Amy, that I don't know any lawyers that are so sort of ultimately committed. And it's an overused word, but you have to be passionate about it, really, and truly believe it. So I do think there is a cost. I think I'd be surprised if anybody out there is doing it doesn't feel.
I think it's a cost under reward though, isn't it? Because it's not necessarily like a big snowballing effect that builds up on you. It can do at times, and I think you can have really tough weeks. And sometimes, I was watching a programme on TV the other day with my husband, and it was someone who'd had a serious injury. I think it was one of these programmes, where they do the homework for them. And he was saying, "Oh my word, have you seen this?" And I just said to my husband, "What do you think I do every day?" And he was saying, "Really, you go out and you talk about all these things." So there are weeks, I think, and particularly if you've got a lot of new cases and you're seeing all the tragedy in 1 week, it's hard. But then the next week you might go back and see a client for whom you've got an interim payment. They've moved into a lovely new house. They can get around that house completely unimpeded, and they've got the vehicle that allows them to get out and about. And when you see the change in them, that's when it makes it all worthwhile, doesn't it?
Yeah, and a sort of segue from that is I think that you need to, well, one of the great things is that you have to become an expert in so many other fields. So we're kind of experts in how to adapt a house, or prosthetics, or different equipment, different therapies, and whilst at the same time you can't be the expert, because you have experts in that. You get to know these things, so you have a vast range of. I think there's probably that much law and this much of other stuff really, which for me makes it really interesting.
Another question. From
So, obviously, when you're operating a no-win, no-fee sort of policy, you must have a pretty good idea that whether a case is going to succeed or not. So, what sort of percentage do you fail if every case is easy?
Yeah, get me on the vetting funnel. It's different for different areas of personal injury. You tend to investigate a lot more medical negligence cases that end up going nowhere than you would do, say, for a serious injury as a result of a road traffic accident. And it's often actually really hard when you've made that emotional bond with the clients, and you're desperate for them, to be something for them to be something in that case, and just for whatever reason, it ends up that there wasn't any negligence there. But that doesn't make things any easier, of course. And I always remember a spinal cord consultant who said, it's awful. I come onto my ward. It's almost you've got the haves and the have-nots, and they'll have similar injuries. It's just that one's got the benefit of being able to pursue a successful legal claim and get all the interim payments and the best of everything that should go hand in hand with that. And then you've got somebody who can't. So it very much varies. But getting that judgment call right at the start, of course, it's very tricky, but really, really important. Again, another skill that you pick up and learn and develop.
Mark sort of touched on it a little bit, but how much of medical law that you study at university is actually put into practice, and what's your average day like?
Okay, I didn't study any medical law at university, so I did a psychology degree after but moving from engineering. So I was quite crazy mixed up with really. I did law, and it was personal injury that I was interested in, because I was interested in the biology and psychology and so on and so forth. What was the question? Oh, how much was my normal day like? Okay. Well, my normal day at the moment is it's mainly management actually, as things stand. But I do a lot of, if you like, strategizing cases with my more junior team or senior members of the team. So it's a very office-based environment. But I think the average day for a serious injury lawyer working on cases is split between analysing evidence. So in our case, talking here about chances of winning medical negligence cases, we have to look at the medical records. In a medical negligence case, you've really got the client story, which often is very garbled and you're not sure, and then you've got the medical records. Ultimately, you get the medical expert reports. So that's a sort of set of stages you go through, and it's really understanding records forensically, and how to then question your expert who may be answering the wrong sort of question, for example. A lot of medics may think that they know some of the law, and you find that they sometimes answer the wrong question. So forensically analysing the evidence. At the other end of the case, though, we'll be doing the joint settlement meetings, as I described, and you would expect to do at least one or two of those a month if you were working in this field. In between that, there's this very big area where you are progressing the litigation. If you're getting interim payments, as we've just described, that this is a whole other phase that occurs, which is, okay, we now get an interim payment. Can we buy our house? Can we adapt it? Can we get the therapies that we need? So one of the skills that you develop, one of the knowledge areas that you develop, is you become almost a purchaser for services when you're at that stage of the case. And you can have so many experts involved. You've got the claimant experts, the defendant experts, you've got the neutral experts who are advising you on putting in place the rehab and all of the package. So you're handling cases across the lifespan of a case. So you have cases at all different stages. And depending on your level of experience, you'll be either directing that, which is a lot of what I do, or you will be working as probably I like small teams of no more than 3 people. So clients has always got somebody they know to contact who intimately knows their case. But you can get the work done at the right level, so you're not having a really senior lawyer dealing with certain areas of the case which you can't recover the costs on. So I don't know if that answers your question.
I might be a little bit more substantive in my answer to this question, is that what's a normal day? This is the best thing about our job. There is no normal day. You can, and because we're dealing with the people in these particular situations, you're doing different stuff the whole time, which is always stimulating, which is always emotionally rewarding. And it's absolutely the same for you as well, isn't it?
It is different every day. For me, some days I will be in court, but not very often actually, even as a SIL. And people probably think that my role is mainly in court. It isn't. Generally, I'm working with the likes of these guys, going out, seeing clients in their own homes, talking about liability with an accident reconstruction expert, where you've got to remember all your physics and go into detail like that. Another day, perhaps having 6 medical experts in conference with you and trying to draw together all this very complex evidence. And another time speaking to an absolutely distraught family who have just suffered something that is utterly life-changing, just getting to know them and building up a little bit of trust so that you can then go on to help them with all these issues that they've got to consider.
It's interesting, Mark and Amanda, that you've both got science backgrounds. Do you think that helps to go into this area?
I think you need to be quite analytical. I don't think you have to have a science background, but I do think you have to be quite disciplined and analytical.
I guess from your question, you're interested in medical law though, and you're wondering how much of that might be applicable on a daily basis. I say a hell of a lot. I'm constantly saying to clients, I'm not a medic, but I'm not a doctor, but this is, and you, because you've been doing it so long, and you just gain so much sort of knowledge and experience just by osmosis really from what we do. You're usually right, and obviously you defer to what the medical experts say. But if that's what you're interested in, and this is absolutely an area of law, I can say that by doing this job, being a serious injury lawyer, you become PMQ, which is practically medically qualified. And you do.
But you're a history graduate, right? So,
yeah, Rich, yeah.
So for these lot kind of lucky to get into, is there a degree that you favour? Law degree, is that good, or would you prefer they did a different sort of undergrad, or is it?
There's people in this audience who sort of, when I was 18, sort of, in terms of, where I was academically and emotionally, they would knock me into a tin hat, absolutely no question. I did a history degree because, I didn't work in my A-levels and I couldn't have got onto a law degree, even if I'd had the insight to realise that that's what I would have wanted to do had I given it some thought. So, the reality is that, you're already, you guys, you academically you're right up there, you've got every opportunity now. There's no right or wrong way to do it. I got into it through a circuitous route. We mentioned, I think we mentioned in the article, there's 2 ways to get into serious injury law. There's not. There's probably 200 ways to get into serious injury law.
Let's take another question.
Do you think that the rise of TV adverts and sort of the public awareness of PI, we all get annoying phone calls, etc. Do you think that's resulted in a bigger perception of a compensation culture and more fraudulent claims, and how has that affected the industry and collectors in particular?
Question.
Anyone?
Right. Okay. Yeah, it's a really good question. And you know what? I've received 3 of those calls in 3 days. I said, here you go, I had an accident. Pulling my hair out. There's no place for that type of thing, is there, at all? Do I think that great personal injury lawyers should have the ability to advertise their services? Absolutely. Do I think that the general public ought to be made aware of that? I absolutely do. Do I think that there has become a perception of a compensation culture in this country where that there is a perception according to the government, which is great. I'm sure that all of us would rail against that. Are there some bad eggs in our industry? Completely. Are there some bad eggs in other industries? Absolutely. Why is it such a crime in our case? It's because we're dealing with people's lives. Now, of course, the type of personal injury that we're talking about dealing with isn't your 8 people in a taxi all claiming whiplash from a staged accident. You know, these people have clearly had life-changing injury. But I certainly believe that people have the right to know that they can claim compensation if they've been injured. And I think those cases should end up in the hands of the best lawyers. And if that means that that person communicates with, if that great law firm communicates with the general public in a way that that section of the demographic understands, I think that should be wholeheartedly encouraged for access to justice.
We're moving into the last 10 minutes, so let's get as many questions in as we can. Question over here and then to you. Yep.
This question is directed to every one of you actually. I was just wondering, how do you cope with the government change of policy? Because it is my understanding that there is a continued pressure from the insurance industry to restrict consumers' rights to get to the courthouse. So perhaps in this injury industry kind of plans, how do you cope with the government policy change?
Well, we constantly adapt and we move as quickly as we can, effectively, is what we do. The other thing to take heart from, I think, is that things go in cycles. And I'll give you one example. When I came into the law, there was something called Crown immunity. You couldn't sue the government, you couldn't sue the Ministry of Defence. And that was taken away because it's right to, because there should be access to justice. And the government should be accountable as much as anybody else, so it should be Ministry of Defence. Just at the moment, there's a propaganda around that issue at the moment because we're in times of austerity, we're in times of where the long-term propaganda from the insurance industry has had an effect on people. And we're in, you know, we've had a period, I think, in my career where there's been an opening up and there's now a closing down. I suspect when people realise how much rights are being restricted, that there will be a backlash against that. When that will come, I'm not sure. But to answer your direct question, we adapt as quickly as we can, and that's what we do, that's what lawyers do.
Because my chamber is a mixed practice, so we have lots of different practice areas, my perception is that PI lawyers actually are the best at adapting, and I don't think that's just a biased view. And actually we've talked about it in chambers, why that might be. And I think it's because we spend our lives sorting out practical problems for clients, so it makes us problem solvers. We've had to, we don't want to run our cases for years and years and end up in a big contested battle because actually we want to sort it out for the client. We want to get them home, or we want to get care in place. And I think it makes us problem solvers, and I think we can use those skills to adapt to changes in legislation and changes in procedure. So my observation is that we're better than most areas.
Good question.
It's a question for all of you. In terms of medical negligence, do you feel the possible privatisation of the NHS will affect that to a slight extent?
It's bound to, and I don't know if...
Great question, by the way.
I don't know if it is happening. It feels like it is happening sort of piecemeal, I think. And where I have seen it actually rearing its head is where a hospital has already outsourced to another body. I actually found it very difficult to find anyone to stand up for that body and an insurer, and in the end I said to the NHS Trust, you've got a statutory duty, I'm suing you, and it wasn't long before we eventually got an insurer. But I think it's going to make it's definitely more complicated operating in the private arena. We do have private medicine now. The way that works is that doctors will operate in a hospital
and the hospital has nothing to do with the med. You know, it's the doctor who has to take out the insurance. So I think it will make it more complicated in that sense. I don't think that the basic rules around breach of duty and so on will change.
Okay, we're nearly out of time. I've just got a couple of minutes left. There's a chance for a final question if anyone would like to, at the back of the room.
Is there any non-legal work experience that might set us up nicely to get into this stream of the profession? Or should we just go for paralegaling?
Yeah, nice question, nice curious question to wrap it up. Non-legal work experience that stands out. Amy,
Certainly for me, when I'm recruiting, and we're constantly recruiting young people, young lawyers. And for me, what I would say in terms of what I'm looking for on CVs and in interviews is not necessarily the place where you might have had your work experience, whether it's citizens' advice or whether it's working in the pub or whatever it might be. It's not necessarily important for me. It's looking at your enthusiasm. It's looking at how you've approached the whole process. So I love things like Duke of Edinburgh Gold Award. I love people who are doing something different, who are making themselves stand out, who are approaching me in different ways. I had a brilliant email from somebody a couple of days ago asking to come to Fletcher's for some work experience. And apart from the fact that he said Dear Denson rather than Dear Mr. Denson or Dear Adrian even, which I thought was, it kind of stood out and sort of spoilt it a little bit. It was actually a brilliant email and it was a great approach. And I think just thinking outside the box, making yourself noticed, letting it be known to the people you're approaching, whether it's Fletcher's or wherever, whether it's Chambers, letting it be known that you're prepared to go the extra mile, that you're thinking outside of the box, you're not just kind of doing the same old run-of-the-mill stuff. And frankly, if you work hard and your CV shows that you've put the hours in, you've worked your way through university, you've always been a hard worker, personally speaking, I don't care what it is or where it is. Nothing can kind of prepare you for what we do better than actually working in this sort of practice. So it's not so much where else you might go, what else you might do, it's how you do it and how hard working you are, I would say.
For us, it's trying to illustrate you're a Fletcher's person, and because we recruit on our values, they're actually stitched into the recruitment process, the interview process, and then all the way through the career at Fletcher's. So if you can illustrate how you've embraced trust, development, performance and innovation in any way, that will actually shine through. Now, how you do that, totally up to you, but we're quite good at spotting it and saying, yeah, that's really interesting, that really resonates with us and what we're all about, and so that would be my advice to you.
It's talking about what you have done and what you've learned from it, because just saying I did a week's work experience in Fletcher's, I did a mini pupillage in Exchange Chambers, means nothing. But if you say what you've learnt from that and really analyse what you've got out of it, then that's much more important.
Mark, would you like to say
I'm all for this all-rounded person really. So I think you've done other things in your life, whether it's in your interests or whether it's charitable work or you've led something or you've been entrusted to do something. That kind of thing that demonstrates that you're an interesting, thinking, enthusiastic, rounded person who can talk to people of all walks of life and can cope with difficult situations. And how you get that experience and how you demonstrate it. For me, it doesn't really matter if that's many pupillage or an experience in a law firm. Actually, other things for me, I do look at those other things in the CVs and how people have learned from them and benefited from them. So I think you bring that into this work.
I would really go for paralegal work. I think you can get so hung up when you're in your LPC or that sort of stage where you're obsessed with training contracts or pupillages. And it's all you are doing all the time, scouring to see who's advertising, sending off hundreds of applications, driving yourselves insane. Get yourselves into a law firm. Claimant, defendant, get yourself into chambers for there must be opportunities for paralegals in chambers as well. Do what you can to get into a job, because once you're in there, there's things advertised internally, there are opportunities that will come along that you might be better placed to to be successful with training
And Ada, your point is borne out by what happened at Fletcher's. The last 10, 15 training contracts we've been given out have been internal, people coming in, illustrating the Fletcher's people, doing that and then going from there, actually.
So it's that coming in, get your feet under the table, demonstrate your commitment, demonstrate your that indispensability really, and then it's unanswerable. You know, if you're a growing firm, you want those people to contribute. It's so much easier to bring your own people through than acquire people who are half-formed elsewhere.
And that's an interesting model, kind of doing the LPC part-time whilst working, keeping the costs down that way.
Yeah, but we've just recruited a paralegal into my serious injury team who's due to start soon, isn't she, Jen? And what's her situation?
Well, we've had a mix, so we've had a lot of people doing the LPC part-time, and a few that have gone for it and done it full-time as well.
Yeah, so and we're accommodating people when they're working part-time hours with us and whilst they're completing their LPC. So, as an employer, we're being, adaptable and working with young people who come to us. They're great young people. We'd love them to work for us. They're successful in interview, and we're kind of being flexible with them as well. So think a little bit outside the box and try not to get too hung up on just what you think is just the traditional route into a law firm.
That's a nice way to bring the panel discussion to a close. We're going to now have some drinks back over at Fletcher's, and all the panellists will be there. So if you didn't get to ask your question, there'll be a chance to catch up with them over a drink more informally. But before you go and leg it off over there to have a drink, let's have a round of applause.